Now to Kaduna State, where the leader of the Islamic movement in Nigeria, Sheikh El-Zakzaky, has been released after 6 years in detention. Zakzaky and his wife Zinat have been discharged and acquitted by Kaduna State High Court. Justice Gideon Kurada upheld the no-case submission filed by Zakzaky's lawyer, Femi Falana. He said that the witnesses presented by the prosecution had been unable to establish any connection between the charges and Zakzaky.
The court has indeed upheld our no-case submission. The court found, and quite rightly, that the charges that were filed in the year 2018 pursuant to a penal law enacted by the Kaduna State government in 2017 over offences that were allegedly committed in the year 2015 is ab initio incompetent. The court ruled that the charge ought not to be in the first place. You cannot arraign a man for an offence that was allegedly committed, as at the time the said crime was not an offence. And the court was very emphatic in that yes, the Kaduna State government has powers to enact laws, but they cannot enact laws to prosecute an offence retrospectively. On that first ground, the court held that that charge is incompetent.
We have to appeal against this judgment to test it, because you cannot parade 15 witnesses, some of whom are people that are there on ground and are witnesses to the events of the 12th of December 2015, some of whom are soldiers, those that acted there, came before the court, left their commands and came and gave evidence and said, this is what happened, this is what we saw. I gave order for this the defendant to be arrested. The defendant were arrested, they were brought to me, and I handed them over to the DSS for investigation. And you are saying the evidence he gave is nothing. It doesn't have any evidential value. So the judge in his infinite wisdom has decided how he decided. It's the judicial system. We will respect the judicial system, we will respect his decision. But then the decision is not the final decision.
Now, to have a discussion around this, we're now being joined by Malachy Ugwummadu, a human rights lawyer and former General Secretary of the Committee for the Defense of Human Rights. Welcome, Malachy. We hear that the ruling... Good to have you, sir. We hear that the ruling essentially has said that the charge is incompetent. The charges should not have stood to begin with. This is 4 years on. And you heard the prosecutor saying, well, what happened to all the witnesses? Are you rendering their witness of no effect? Is this some sort of a farce, or are we to rejoice on this ruling?
Well, without taking much of your time, just a point of correction. Being the past national president of the CHL, I was once a general secretary, right? But I'm the
immediate past president.
Now, I think that both sides are well within their rights. Prosecution is well within its right to be provoked and angry, and I hear that he intends to do the right thing, which is your right of appeal. No doubt about it. But the court is also well within its rights and competently too. The point made there is that no Nigerian can be punished for a non-existing offense as at the material time when the offense was alleged to be committed.
Okay. We seem to have...
That is the exit. Numerous old cases, one of which is Ako and Fagbemi. You cannot punish any Nigerian for an offense that does not constitute a crime at the material time when you made those charges against him.
Mr. Malachy.
That is a fundamental right. It's a constitutional right. Give or take, by and large, we are at a point where Nigerians will also begin to consider what manner of charges were such that fell like a pack of cards at the point of no case submission. You file a no case commission in a criminal matter when you are convinced and able to convince the court that there are no evidence whatsoever linking the defendant, that's the accused person, to the crimes that are alleged to be committed. And secondly, that even if the court were to rely on the evidence that are produced, in the words of the prosecution, almost 15 of them, they are so thoroughly discredited that they are of no moment and will lead to nothing. It is at that point that the trial court, whether a magistrate or a judge of a high court, will come out and say that based on what is before me, without going into the merits of the matter, there is no basis, there is no reason whatsoever for the defendant to open his defense. That is the technical meaning of no case submission. We have used it on many occasions. So it is not about rushing to court. Now, it is about properly collating, aggregating the evidence in a watertight manner in such a way that in the event of trial, he or she cannot escape the ineluctable conclusions that will be arrived at by the court. So what happens after 6 years, 6 whopping years? Who pays for all the harrowing experiences of this man?
That's where my next question.
Can he be restituted?
Malachi, you permit me to actually interject at this point. I was about to ask you that particular question right now because the lawyers to El-Zakzaky and the wife are saying that they will be seeking for damages against the Kaduna state government. Some are saying they should probably sheath the sword and bury the hatchet. For you as a human rights lawyer, should they press for damages against the government for this horrendous or these horrific times they've actually been forced to go through over the years and gotten to this particular point?
My brother, I didn't quite capture all the questions, but I imagine, so I'll go ahead. I imagine that the thrust of what you want me to deal with is, does El-Zakzaky and his wife stand a chance with respect to any remedy that can arise from this kind of judicial treatment? I mean, this kind of treatment. The answer is yes. There are multiple options that he can take on. First, he can activate his right to challenge the prosecution for malicious prosecution. That is one. The argument may come that you cannot sustain that because the matter was not decided on its merits. And please pardon me to say that what happened, I have had many commentators say that he was discharged and acquitted. He was never acquitted. He was discharged. And that is the remedy you get at that point of the proceedings. You can only be discharged, you cannot be acquitted because the matter did not go its whole hog. So he can, as a matter of fact, and at this point, initiate an action for malicious prosecution on the basis of the fact that he has been made to go through these horrendous experiences willfully on account of unsustainable, unsubstantiated evidence that they brought to the court. He could flag. Secondly, he can take out a fundamental right enforcement procedure to seek the liberties that were abridged while he was denied all of his rights, as it were. The argument can arise whether being on trial, whether he could sustain those allegations of breach of fundamental rights. But the courts are always there to determine, depending on the perspective that you have brought to bear on the peculiar case that you have brought before the court. So there are a couple of remedies at his disposal. And I'm sure that my senior comrade and colleague knows the best thing to do in the circumstance.
Okay, Malachy, you said what manner of charges could have been tendered such that they were all dismissed like a pack of cards on a no-case submission. I want you to draw a parallel between this particular instance and the case being brought against Sunday Igboho, Sunday Adeyemo, and Nnamdi Kanu, where we're already asking the question regarding Sunday Igboho as to what are the real substantive charges against him. 7 rifles do not necessarily amount to stockpiling of weapons. Please, briefly.
Well, a few distinctions need to be drawn here. In the case of Sunday Igboho, do not forget that at the moment, the legal proceedings, the judicial fireworks is abroad in the Benin Republic, Cotonou precisely. Is that at the moment he is contending with irregularities, charges around irregularities in his travel documentation, travel requirements. That is what he's facing at the moment. And that the charges proper has, for which he took off from Nigeria, has not been preferred against him. So we leave that. In the case of Nnamdi Kanu, you would see that it's a different agency of government
on Newsday
that is handling that, and that is the DSS. Do not forget that these charges were already existing.